Now, what are the advantages of the system I propose? What are the advantages of serving process through Article 10 of the Hague Convention? And no doubt, it has exactly the same value, legal value, as the central authority. Well, the advantages are the following. On the one hand, you don't need to translate your documents. No, documents will be served in the language of origin. And this is contemplated in many codes of civil procedure of Southern European countries. In the French Code of Civil Procedure, they specify that documents can be served in the language of origin. So there you go, you have an economy there in relation to the translation of documents. But you also have an economy in the sense that that translation will not be questioned because there's no translation. If you do a translation, a good attorney files a motion to quash or a motion when you're going to execute or you're going to enforce that document abroad, will destroy your file, even though you have won the case, simply because the translation was so bad that it didn't work. Also, there's no reject because of bad translation. As you know, it's in some jurisdictions in Europe, and I have seen that, the central authority have rejected to complete a service of process because the terminology used in the translation was not proper, was completely confusing. And they couldn't understand, even though it was in Spanish, what have been done. And I will be very pleased to show it to the United States government how the translations being done in the United States to be sent abroad to the central authorities are simply disasters, are really bad translations. Anyways, I have little problems like that. Article 10 is divided in 3 sections. Section A, 10A, that it's by mail or by fax. Section B, that it's by judicial officer. And Section C, that it's by a qualified professional. Now, we said that this Article 10 of the Hague Convention has the same value as the method employed or the method that you can use of the central authority. It has exactly the same value. But what happens is that some countries have opposed to the different sections or different articles of the Hague Convention. That's why I ask you to download that table of applicability of the Hague Convention. In the case of our work, none of the Southern European countries have refused or have opposed to the application of Article 10 of the Hague Convention. I mean that Portugal, Spain, France, Italy have not opposed to service by mail, have not opposed at all, have not opposed to service directly by a judicial officer without passing by the central authority, and have not opposed to a qualified professional to complete service in their jurisdiction. These are Article 10A, B, and C. Now, why is Article 10 giving so many problems? Why we cannot simply serve by mail? Well, we have been facing, jurisprudence have seen it in 2 different levels. On the one hand, service by mail have been considered in the United States by some jurisdiction as evidence of an address, not evidence of delivery of a contents. Indeed, when you look at it, it's a little formality, but it's interesting because it shows how it goes, that the summons are stamped and signed as delivered and the date. And when you serve through the mailman won't do that. But on the other hand, when you serve by mail, and when I say mailman, I'm talking about also private carriers, but when you do that, when you serve by mail, who certifies that the contents you're sending by mail is correct? Who certifies that you are sending 50 pages and not 50 blank pages? No one. That's why countries like Spain have designed a system based on problems that have appeared in jurisprudence. In the moment that a court order have been tried to be enforced, have designed systems like the Burofax. The Burofax is a Spanish system which is ideal to serve by Article 10A, but it's controlled by the post office. It means that the Spanish post office serves as a process server. They will indicate the date, the hour, and the person where documents were served. Unfortunately, they will certify, of course, the contents of what is being served. They will stamp each page saying it. Unfortunately, if you're in Spain, you can do it that way. If you're abroad in North America, the thing gets a little bit more complicated, and it's not as simple as that. Then, when you consider serving by mail, not only you have these little problems of that you're serving something that you don't know, but that you have also a little problem is that if you use the public carriers, I'm talking about the local government postal services, and it is my experience, 80% of the cases, their return receipt will take ages to arrive, and if it arrives, because often it doesn't come back. Often it's lost. Often they don't have the time, they don't care about it. But even though they have the time, and you receive it, let's say that 70%, let's say that you receive that return receipt, that pink slip, that they will send you back, you will notice that there's a signature, but there's no name, there's no hour, there's nothing. You don't know who has been served. You don't know, is it the gardener? You don't know, is it Pierre, Paul, Jacques? You don't know. So this is another problem that have caused also problems have passed motions to quash have been granted because of this. So forget about service by mail, and even though you say I can use DHL, I can use UPS, forget about it, it's really a disaster. Don't use Article 10A unless you do it through a law firm like ours. Why? Because on the one hand, we're in Europe, and we will use the postal service corresponding to its jurisdiction. In the case of Spain, we will use the Burofax. In the case of France, we will use a certified. And in the case of Italy, we will do it the right way. And big advantage is that we don't even need to receive that back, because we will get it immediately from the post office, because we're there, we're present, we're physically there. Our prices for service of process by mail are extremely cheap. We do it for 300 euros, which is really peanuts. Simply the legalization of documents, the preparation of documents cost you. Anyways, let's go to Article 10B. Article 10B says, and as I said, it has the same value as the central authority system, says that you can contact directly a judicial officer in the jurisdiction abroad him to serve your documents. As simple as that. Big advantage, you don't need to translate the documents, even though I recommend you to translate the documents, because most judicial officers do not speak English or do not speak the language. And again, even though the defendant will speak the language, the judicial officer will examine your documents again. He will look at them not only to check the address, and big advantage of using a judicial officer is that he has the power, the capabilities, and they often do it. They will charge you probably a little bit more, but they will definitely look for the proper address of the defendant to serve properly. Little disadvantage of judicial officers is that they are submitted to their own law, and therefore they won't issue affidavits in English. They will follow the procedures that are established in the local codes of civil procedure to serve documents, such as posting a note in the door, such as posting a note in the city hall, things like that. So it means that that service could end up being not a private personal service, but a substitute service, could end up being a service by publication, or could be simply a service by simply call, an invitation for the defendant to go to their office to pick up the documents. So this is a problem when using the judicial officer. It's how the law in each country provides or controls how a judicial officer should act. Finally, there's a very big important problem is when you're using a judicial officer, you have to make sure that the judicial officer is competent to serve those documents in the jurisdiction where you want him to serve. Judicial officers in Europe have a territory of their own, and they cannot go away from that territory. Of course, this is not open market. Judicial officers are controlled by the government, and they have to act in a certain area only. They cannot try to serve abroad. They have to, abroad I mean outside their jurisdiction. And their fees, as I say, are controlled by the government.